Hello everyone, I'm Dr. Moniaree Jones. I'm an associate professor at Stanford University, and I want to thank you for attending this presentation today. Um, I also am a legal nurse consultant in private practice on the side, and I have worked previously in two defense law firms in downtown Birmingham for quite a few years. I was asked to talk to you today about nursing malpractice lawsuits, and so I hope that I can share with you some of the knowledge that I have gained from working in this field for quite some time. So what just happened? Protecting yourself from medical malpractice claims, some legal and ethical guidelines for safe practice. And I don't have any conflicts of interest in making this presentation, and there are no disclosures. Today I hope to give you some objectives of identifying elements of a lawsuit so you'll know what actually a lawsuit consists of, and list some ways that you can protect yourself from litigation. I think it's important to talk about ethical concepts first and talk about what ethics really is. It's a study of philosophical beliefs about what is considered right and what is considered wrong in society. Bioethics, on the other hand, is used in looking at ethical dilemmas. There's a lot of controversy sometimes brought about by the medical field, like should a physician assist with suicide assistance? And in drug research, for example, you're giving someone a drug that hasn't been tested and you don't know the outcome or result of it. So, what is going to happen to the person that's taking this medication that hasn't been studied? So, the ethical dilemmas of things of that nature. And maybe there's a conflict between two or more courses of action. For example, should a person who's diagnosed with schizophrenia become pregnant and have a baby? So these are just some ethical concepts that nurses are faced with every day. There are 5 principles of bioethics that we need to talk about. Beneficence is the duty that you have as a nurse to do good. The little things, like the slide says, spending extra time to care for a patient to calm them down, and recognizing autonomy, respecting the rights of others who make their own decisions because they have the right to refuse medication. I teach psychiatric mental health and research and also a graduate class on curriculum. And in I have used these slides, some of them. I've revised it for today's talk. But it's important to understand that patients have rights. Psychiatric patients can refuse their medicine unless they're a danger to themselves or someone else. And a lot of nurses think, well, you can just give them that medicine if they have a psychiatric disorder, and that's not necessarily true. The physician has to make the decision if they are a danger to themselves or others. So autonomy, justice. We want to distribute our care to each and every patient equally. You can't devote all of your attention to just one patient. You have to serve everyone equally. Fidelity is non-malfeasance, which means maintaining loyalty and commitment, doing no wrong to a patient. You need to keep up your continuing education. That's a perfect example. We've actually had records subpoenaed to see when was the last time this nurse or physician had some type of continuing education on that subject. So it's important that you, as part of your ethics, keep up with what's the best way to do something. Veracity is one's duty to always communicate truthfully. A patient has the right to know about what that medication that you're about to administer is for, and are you giving them the right dose? These types of things are part of good bioethics. In the medical malpractice world, we talk about civil wrongdoings and criminal wrongdoings. Medical malpractice mostly falls under civil rights. There are sometimes criminal wrongdoings. For example, there was a nurse, I think it was in another state, Michigan, I believe, some years ago that was getting a thrill, had actual mental illness problem, and was getting a thrill out of seeing people being called for a code on the night shift. And they found out that this particular individual was injecting these patients with potassium chloride, which was causing them to go into a cardiac arrest. That would be a criminal wrong. But most nursing malpractice cases are civil wrongs that are determined by the result of monetary fines and sometimes continuing education or suspension or revoking of your nursing license. So under civil rights, a person is guaranteed the same rights, and we have federal laws and state laws, and the state laws can differ from state to state. For example, everyone, even mental health patients, have a right to vote. They have a right for a driver's license. They have a right to marry. And all of this is in the Self-Determination Act of 1991. And this act is one that required hospitals, home health agencies, and hospices that receive Medicare and Medicaid reimbursement to inform patients at the time of their admission of their right to a central part in all their healthcare decision making. And these are those papers that you sign when you go in the hospital or an outpatient surgery clinic or something that tells you about these rights. They want you to know that you do have a right to participate in the decision making of your care. We're going to talk about two types of commitment. And I'm going over some things before I get to some of the meat of the subject because I feel like it's important for you to know that you can't just put somebody in a hospital for no reason at all. We have two types of commitment, which is voluntary and involuntary. They're pretty self-explanatory in that involuntary is the person is going in the hospital because a physician or a judge has determined that that individual needs to be evaluated to see if they have a problem to keep them in the hospital, such as mental illness. The writ of habeas corpus means the right to challenge an admission or to free the person. So we're always wanting to think about any admission as one of the least restrictive environment. That's very important. You never want to use more than what is the least restrictive. An example of that would be if you have a patient who has a mental illness, say for example, that can be seen on an outpatient basis because maybe they're not as severely ill for needing inpatient admission, then you need to use the outpatient treatment versus inpatient because that is the least restrictive type of treatment. Now, voluntary is easy to remember because it's kind of like I volunteer to go into the hospital. I know I have a problem. I know I'm sick. And this can be brought about by a patient themselves that volunteers to go because they know they're sick or have a problem, or a guardian um, that says, you know, I'm signing this person in because they're not of age and they're sick. It's a temporary admission, and the person at the time can be confused and demented, but they are willing to go and they need an emergency admission. However, they are free to leave at any time because this is a voluntary admission. So you can't hold an individual against their will. An involuntary admission is, again, kind of self-explanatory, is it's involuntary. It's without the patient's consent. There are only two um, people that can actually sign a person in a hospital on involuntary admission. It's a physician who signs a consent order or a judge who signs a consent order. And the patient must be a danger to themselves or others in this type of admission, suicidal or homicidal. This is mandated by court that they go in for 24 to 78 hours, depending on what state and what their laws are, for an evaluation. And at that period of time, a court hearing is held to determine, based on the medical team's evaluation, whether the person appears to be sick and needs to stay longer or does not appear to be sick and may go home. So it's very important to remember that you can't just go in the hospital. These rules have to apply. When a patient is getting ready for discharge, there's some legal things that are involved and different types of releases. A conditional release requires treatment for a specific amount of time. For example, I'm going to let you go home from the hospital if you agree to go to outpatient testing for substance abuse, or you agree to show up in court on such and such a date, or the conditional release based on involuntary admissions. And unconditional release is you can be released with no conditions. You're free. You're autonomous. There are no conditions. You're just being released. And then release against medical advice. I know you've all heard of that, AMA. We always try to get the patient to sign an against medical advice form because you don't want them to leave against medical advice. You can't hold them there, though, because they're not involuntarily committed by court order. So you need to make sure they're not a danger to themselves or others. But you try to get them to sign the form saying, hey, you're doing this. We really don't want you to, but they are free. Patients have certain rights under the law. They have a right to treatment that is humane. They have a right to refuse treatment, and this can be often hard for some family members to understand because they say the person's not taking their medicine. They're not getting better because they're not taking their medicine. So why can't you make them just give it to them anyway? Well, you can't because they have rights. Again, the only time you can give medication to a patient against their will is if they are a danger to themselves or others. Like if you're on a unit in the hospital and that individual is liable to harm someone else on the unit, then the doctor can make the decision along with the treatment team a lot of times, but he alone or she alone can make the decision to give the medication. Patients have the right to that informed consent, though. Let's consider a 27-year-old male that's court committed by his parents to a unit that you're working on and has a diagnosis of paranoid schizophrenia. He lashes out at the staff and they attempt to give him his medicine and he states, you're trying to poison me. And the family might ask you, can you force him to take his medicines? Well, I think I answered the question for you. How would you respond to the family? You would have to explain the laws that I just explained to you about the person needs to be a danger to himself or others before you can force someone to take medication. And that's something you'd have to discuss with the physician. And you might want to wait and see if it, changes into something like that. But right now, the patient has rights. And you need to make sure that the benefits outweigh the negatives. And again, we're looking at less restrictive environment, which it would be not to give until you had to. There are rights surrounding involuntary commitment, psychiatric advance directives. These come in the forms of living wills, powers of attorney, durable power of attorney, and rights regarding restraints and seclusions. You have to be familiar with policies and procedures. And a perfect example is there are certain policies and procedures for each agency or institution that has to do with how frequently or how often you check restraint. And those rules and regulations are even stricter when it comes to children and adolescents because they're checked more frequently. And I can't stress to you the importance enough of documenting each and every time that you check on a person with restraints to be in compliance with those policies and procedures. Patients have the right to confidentiality. You can't just call a unit and ask, if someone is there. You can't tell them that. I know you all know that. And lots of times there are passwords that family members have to know, and they're the only ones that are supposed to have the password. There are a lot of legal considerations that you have to take into account when there's confidentiality. Taking care of some patients may be simple if they're, in the hospital and they've had a diagnosis that's quite frequent, like a heart attack or something, but most psychiatric patients, you're going to know who that person is. If it was the person down the street that was naked and they arrested or what, these stories are on the news maybe sometimes, and so they're easier to identify. Psychiatric records are very hard to get from the court because they require HIPAA consent from the judge, and that's to protect, again, the rights of patients, in particular those with mental health issues. And you have to pay close attention to the fact that unless a patient gives you consent, especially a mental health illness, they can take whatever they wanted to take in their mind with them to the grave because they can't, even after they're deceased, a physician or a counselor or anyone that's caring for that patient cannot reveal anything that that patient did not give consent for. So they take it to the grave with them, basically. The confidentiality is really big, and that's important to know. There is, however, one exception to the rule, and that is the duty to warn. And you know, as nurses and teachers and all, we have, and physicians have duties to protect individuals by warning them of child abuse or neglect. You know, that's in our statute that we need to report elder abuse or child abuse. If not, we can get in trouble. But the exception I'm referring to is the Tarasoff versus Regents at the University of California, where a psychotherapist had a duty to warn a patient of a potential harm by a victim who was being released, not a victim, of a patient who was being released from a hospital who had made a comment while the person was in the hospital that they were going to go and take care of or kill another individual, and this psychotherapist failed to warn the potential victim, and of course a death occurred, and so therefore California law uh, was changed over this, the Tarasoff versus Regents of the University of California. And this slide has page 106 because I use this slide a lot in my classes, and you won't have page 106 because you don't have the textbook, but this is important to know that you have the duty to warn someone if they mention this. I talked about criminal laws and civil laws. Well, a tort is just another name for a civil wrong. And I told you there are money damages tied to it. So if you're a nurse and you do something that is wrong and divert drugs or do something that's wrong in your work setting, then that's a civil wrong, and it will come with some monetary damages or fines, along with probably some continuing education that's required by the Board of Nursing, and maybe even a suspension or revoking of your nursing license. Suspension is for a temporary length of time until you've completed certain requirements that the Board of Nursing requires, and a suspension is you're not going to get it back. So there are certain rules that have to be followed once a wrong is done. An intentional tort is a willful or intentional act to violate the rights of another person or their property. Examples are assault, battery, false imprisonment, invasion of privacy, and defamation of character, which is slander or libel. We're going to talk a little bit more about this. There have been cases in which another nursing assistant or nurse has gotten upset with a patient in a nursing home or another setting and slapped them. That is definitely a no-no. False imprisonment could be something like a patient's yelling out and they're annoying you, and you're trying to give your meds on the night shift or evening shift, so you just sedate them a little bit more because they have a PRN, and then the person winds up dying because they've got a depressed respiratory rate, and it leads to their death, and so therefore, that's false imprisonment, or closing a patient's door to keep them from yelling so that they can't really get in touch with a nurse or somebody if they need one. That's false imprisonment. And of course, invasions of privacy and defamation of character, slandering or talking bad about someone else. There are things called unintentional torts, and these are things that you don't really intend to do, but they produce injury. For example, you have the duty to drive safe, but if you don't drive safe, you could face charges or DUI. You thought you didn't have that much to drink, and you got in a car and you kill somebody or harm someone. So that's negligence and malpractice. Those are unintentional sometimes. Another thing comes to mind about maybe using a product that it's not originally meant to be used for. A water pick, for example, can irrigate an ear, but if a person's got a hole in their eardrum and you're irrigating their ear with a water pick, that's not the intentional use of that device, so that could be a problem if that's not in policy and procedure. This next slide is very important in my opinion because as a nurse, you have nurse written across your forehead. A lot of times people will ask you, do you think this is a lawsuit or not? Do you think I have a lawsuit? Well, the way in which you can tell if you truly have a lawsuit is that there are certain elements that must exist, and there are 5 of them to prove negligence. The first one is a duty. You have a duty as a nurse to care for the patient. That's your known practice, your known profession, your known knowledge base. And then you would have had a need to breach that duty something that fell outside of the standard of care, or you didn't do something that was reasonable and just. That would be breaching that duty. And then there needs to be a cause, approximate or in fact cause. In other words, all that is harm. Because of the breach of duty, some type of harm occurred. And I'm going to give you an example of this in just a second. Then there needs to be damages, suffering, loss of health, loss of money, earnings, property damage, consortium. That's a frequently used term. And then, which means loss of enjoyable sex. They can even claim that. So the last thing is foreseeable harm. The nurse could foresee the possible damage from the action of whatever they did, but they did it anyway. The water pit was a good example of that. So you have to have all 5 elements in order to prove negligence. I give my students an example of a nurse who was giving out medications, and she goes into room 110 and breaches the duty because she doesn't go through all the necessary checks that she should have before giving the medication. Right room, right patient, right time, all of those things. And she accidentally gives the patient in room 112's medication. Just so happens that 110 is not allergic to penicillin, so nothing happens. If she does the right thing, she'll fill out an incident report about it, because she's going to have to go get another medicine for the pill for the right patient if she does the right thing, and nothing happens. So there is no lawsuit. There is no cause or damages. They're missing those 2 elements. But let's just say that 110 is allergic to penicillin. 110's airway swells up. You have to call the emergency response team. They have to insert a trach, and the person has a permanent scar on their neck from the trach and goes through, a lot of processes with illness and this kind of thing. So there you have a duty that was not done well. It was breached. You have a cause, wrong medication. You have damages. The patient was allergic, had to have a trach, and suffered some mental cognitive issues perhaps, and some other scarring and damages. And there was foreseeable harm because you didn't do the steps that you knew you were supposed to do by checking all of the rights. And so therefore, the patient had harm. So anytime you need to know whether or not you think you have a lawsuit, these 5 elements are the things that you should go through in order to determine. When a case is brought to a plaintiff attorney, they sometimes will have a nurse or another attorney or associate who will go through this when they look at the chart to see if these items exist. There are guidelines for ensuring that there is adherence to the standards of care. Negligent, irresponsibility, or impairment, and the duty to intervene and the duty to report. And we know that the Board of Nursing's job is to protect the public, to keep the public safe. So they are the ones who can restrict or revoke your license. And so I think sometimes in our everyday work we get caught up and we forget how important and how blessed we are with this opportunity to have a license and to protect other people and care for them. Some examples of assault and battery and negligence would be assault, the threat of an unlawful force to inflict bodily injury upon another individual. And that would be that person who, slapped somebody because they were tired of hearing them talk or ask for something. Medical battery, and there are other examples, that's just one that comes to mind. Medical battery would be intentional or unauthorized harm, or offensive contact. You're treating somebody without their consent, giving them pills, for example, without their consent. Or the clinician who fails to obtain consent before a procedure, that's battery. Failure to respect an advance directive, CPR. False imprisonment, such as not discharging a patient, holding them against their will when they're voluntarily committed. Negligence is a breach of duty when reasonable care for a patient is expected and the nurse is responsible for it, and it results in some type of personal injury because they neglected their duty. I Can't stress to you enough the importance of documentation. You know, we use electronic medical records nowadays, and it's, in my opinion, they're kind of cookie cutter. And so it's very important to use the narrative to write notes to protect yourself and also to protect the patient. So the usefulness of a record is determined by what the person reads in the record later and how accurately and completely it's going to portray what actually happened and the behavioral status of the patient at the time it was written. That's why it's so important. And you never ever want to do anything except state the facts. Don't elaborate, state facts only. You can, I mean, if you do elaborate, it better be elaborating about facts. You must document a patient's intent to harm. You must document what's being done, and you document any need to warn, and you don't document hearsay or anything that would throw your coworker under the bus, because you only want to document the facts. Because if you say, I tried to call Dr. Smith, but he was out to eat and no way to contact him, or what, that makes you, the nurse or the person that's doing the documentation, look bad. It makes you intentionally look like you were defaming the other person. So you never want to do that in documentation. Medical records are used by the facility for a lot of reasons. We use them for quality improvement. They're used as evidence with risk management. And again, that electronic documentation, it's a lot better that you can read typing of words better than handwriting a lot of times. But if it's too cookie cutter and you're not using the narrative, it can be another problem of not being enough written about things too. So which individual with mental illness may need involuntary hospitalization? Would it be a person with alcoholism who's been sober for 6 months but starts drinking again? Or would it be an individual with schizophrenia who stops taking their antipsychotic medications? Or an individual with bipolar manic phase who hadn't eaten in 4 days? Or someone who repeatedly phones the broadcasting service television network for news tips? Well, if you said it was C, you would be correct, because the key in this, they're all important, but hadn't eaten in 4 days would be more important. Legal and client's rights are suspended when a client is hospitalized involuntarily. Is that true or false? That is false, because involuntary admission requires that a client retain freedom from unreasonable body restraints and the right to informed consent and the right to refuse medications, including psychotropic or antipsychotic medications. Other rights are preserved as well. A client plans to have electroconvulsive therapy. Now, we haven't talked about that, and they're beginning to use electromagnetic stimulation more because it's safer with pregnant people and all, but there is a very high success rate with electroconvulsive therapy. It's done very humanely from the way it used to be done years ago. So what member of the team is responsible for obtaining the consent form? And this can be a little tricky, because probably you want to say the registered nurse, because that's actually who does get the job done, but it's ultimately the physician who must make sure it's done, because they're the one going to be doing the procedure, and they need to make sure. Now, they're going to fuss at you if you didn't get it done, but it is their ultimate responsibility. A nurse was the case manager for a client with a serious mental illness for 6 years. The client died by suicide 1 week ago, and today the client's spouse asked, I always wondered if my spouse was a victim of sexual abuse in childhood. Can you tell me about that? So would the nurse be able to disclose that information to the surviving spouse? And the answer is no, because a person's reputation can be damaged even after death, and therefore it's important that nurses not divulge information that could not be legally shared before their death. So nursing malpractice claims and the cost are very significant. The average cost of a registered nurse's malpractice claim is around $202,000. And nurses are not seen as what we call in the legal world deep pockets. The physician is, or big corporations and companies and things, hospitals, but nurses don't have normally deep pockets, meaning a lot of money. But $202,000 can be a lot, hence the importance of malpractice insurance. And so death remains the most common patient injury in a lawsuit with nurses. It accounts for about 44% of all the malpractice claims brought about by or against nurses, not by them, but against them. Comas are the highest severity among patient injury claims, around 621,000, and they are often due to medication errors, and the high cost reflects the need for lifelong medical care. And that's because when something happens, there is a life care plan done on an individual where the attorneys have to use a special person who's trained in doing this, how many wheelchairs they're going to have for the remainder of their life. If they're 50 years old, do they need 4 more wheelchairs in their lifetime, or 6? So there's a life care plan that's done that runs that cost up because you have to provide for the care for the rest of their life. And medical surgical is the most frequently sued nursing specialty, about 36%, and gerontology comes in second at about 16%, followed by home health and hospice at about 12.4%. That's where the lawsuits seem to be the most, although they can happen. Allegations related to treatment and care present a high percentage. 45.9% of all malpractice claims against nurses are related to the treatment and continued care. Experience as a nurse does not equate to less risk of malpractice claims. The majority, 85%, who experienced a malpractice claim had been in practice for at least 16 years. And a lot of people think, well, that's all the young nurses that are inexperienced that are causing all these malpractice claims. It's not true. I think maybe because they're still a little bit scared, they're trying to be a little extra careful, and those who've worked for a good period of time may be a little more relaxed and a little more autonomous about some things that maybe they shouldn't do. So that, to me, is a very interesting statistic. The number of licensed defense-paid claims increased by about 15.4% in 2018, according to the Nurses Service Organization, and the average cost to hire an attorney to defend a nurse before the state licensing board increased by about 19% to about around $4,000 during the same period. Unprofessional conduct related to nurses is a large majority of licensed complaints, about 24% made against registered nurses, and the majority of the complaints for licensed practical nurses or vocational nurses have to do with medication errors, because we all know that they're the ones that usually give the medications, especially in the nursing homes. I wish I could show you this. Maybe you could take a picture with your phone, or cut and paste this. We can't cut and paste it, but take a picture with your phone and then type it into and watch this information here about case studies from the Nursing Service Organization. I was hoping it would play on the slide, but when I tested it earlier, it would not come up because I'm recording it. But this is some very interesting information about alleged failure to properly assess and monitor as an example of a case study. The 10 most surprising things from nurses' claim reports are by Nurses Service Organization and CNA, which are nurse malpractice insurance companies, to review and analyze malpractice and licensing claims to help nurses understand the areas of their greatest vulnerability. And so over $90.3 million was paid for malpractice claims over a 5-year period by CNA and the underwriter of the NSO Nurses Professional Liability Insurance Program, and about 5.1 was paid to help defend about 1,300 licensed complaints over that same period of time, to give you some kind of idea about how often it is. To avoid a lawsuit, you need to keep the following things in mind, and that is know your strengths and know your weaknesses. Don't accept responsibility that you don't know how to do or you're not prepared for. And if you make a mistake or an error, claiming that you weren't familiar with the unit's procedures is not going to protect you against liability. You're supposed to know what the procedures are. Just don't do it. Go look the procedure up or go ask your supervisor. Refuse any assignment that you can't safely perform. And that's important because you could be assigned work on a specialized unit and you're not necessarily familiar with everything, and it can be unsafe. And a perfect example of this is several years ago, there was a traveling nurse who went to another state and was working in a NICU unit, neonatal intensive care unit. And this nurse got sick on the job and asked to go home, and they sent a floater nurse to take her place. About 2 or 3 o'clock in the morning, this baby had a seizure and died. And they didn't know why, because the baby had been okay. So they needed to determine what had happened. And was it the nurse that was sick that did something wrong because she didn't feel well? Or was it the floater that was unfamiliar with the assignments, sometimes maybe on a floater unit like she was on? And when they found out, this is kind of alarming, but what had happened is the baby had died and had a seizure because the enteral feeding had been going through the IV line. It was hooked up to the wrong line. And the reason was that, the enteral feeding was in the IV line, wrong place. And how did they find out who was at fault? Believe it or not, there's a chip in the IV administration, whatever pump you might be using. There's a chip in there, and they can tell what time certain lines are running, and so they were able to pin it down to who was actually at fault for that. So it can be a little bit scary. So don't do something if you can't do it safely and you're not sure about it, or have somebody do it with you, double check behind you. And delegate safely. Exercise great care when delegating duties, because you can be held responsible for your subordinates, people that you delegate something to. You need to look at all the things that you use, the equipment, machinery, and make sure that everything is completely safe, and report any incompetent healthcare personnel. That can be very hard to do. And go through the proper chain of command. And get clear orders. Don't treat any patient when you're not sure what the orders are, except in an emergency room. Don't do anything outside of your scope of practice in the hospital or the emergency room, but physicians, physician's assistants, and nurse practitioners prescribe and dispense medication, and the laws are different in each state, so wherever you're working, you need to make sure if you need a collaborative physician or you don't need one in your nurse practitioner, don't carry out an order from a healthcare provider if you don't have assurance about the accuracy of the appropriateness of whatever that is, and follow your facility's policy for clarifying any ambiguous order. Document your efforts to clarify the order and note that you carried it out. Again, that documentation is so important. Be particularly careful with medications. Most errors in medication are the most common and potentially dangerous nursing errors that are made. And this slide says 5 rights. I think it might be up to 7 rights now. The right patient dose, time, route. But you need to make sure that you check all of that, because it's extremely, extremely important. Stay on your patient's good side, and I cannot stress this enough. Trial attorneys have been saying if you don't want to be sued, don't be rude. I like that. If you don't want to be sued, don't be rude. Always remain calm when a patient or his family gets upset. Patients need to know the truth about mistakes and complications. Just be truthful. If you did something wrong, be truthful, and they'll respect you much more for it. And that might be very hard to comprehend, but I always think about that little example of you're thirsty and you go through a drive-through and you want a Diet Dr. Pepper because you drink Diet Dr. Peppers, or you have diabetes and you want a diet drink. And you go through the line and you get your drink and you drive off and you take one sip of it and you realize it's not diet. So either you have to live with your drink that you have that's not correct and your diabetes and decide not to drink it or whatever, or you get back in the drive-through line so that when you get up to the window you can just bless out the individual who gave you the wrong. I have diabetes, you gave me the wrong drink. For all you know, you may get one that's been spit in by that time, which you won't see happen, but you may be given one. And you hate to, this is a silly little analogy, and you hate to say that, but what if you instead you just said, oh my goodness, I think that I got the wrong drink. I may have gotten somebody else's, but this is not diet. I have diabetes, or I'm on a special diet, or I prefer diet, and this is not, that could you help me please? And they're much more apt to help you if you're not rude. And the number one cause of lawsuits is a patient not feeling like they're cared for. That is the absolute number one cause. So anything you can do to divert someone being upset, don't be rude and you won't be sued. Don't ever offer opinions. Avoid offering your opinion when a patient asks what you think is the matter. Reply with just facts. Don't give opinions. If someone asks you for a list of providers, give them more than one. And before you sign, read. Never sign your name as a witness without fully understanding what you're signing or the legal significance of your signature. And always stick to facts. In the legal world, documenting care is important. It's just as important as the actual care that you give. And if a procedure wasn't documented, you know what they're saying is it wasn't done. And make sure you document all your observations, decisions, and actions in the patient's chart, because when it's taken to the courtroom, it's going to be the nurse's best evidence of the care that you gave. And the documentation should follow the FACT rule, and that's factual, accurate, complete, and timely. And most of all, do the right thing. Don't let a patient undergo a surgical procedure unless you're satisfied that that has been thoroughly explained to them. And also don't use any equipment that you haven't been taught to use. And if you're sued and you make a mistake, you'll probably be worried about a lawsuit, and at least, but not initially, you'll be concerned about your patient, but make sure that you have carried out any orders and assessed the patient, and you have documented this. It's extremely important. And don't discuss any situation, and I can't stress this enough either, because if you just got a best friend and you're so stressed from something that happened that day on the shift or something at work, and you go to lunch with your dear friend who you trust to the nth degree, and you just say, oh, I don't know what I'm going to do, and you sit there and you talk to that person at lunch, and then 2 years from now, when lawsuit comes up, which most lawsuits take at least 2 years, and it comes up, and judge or somebody's going to ask, did you discuss this case with anybody at all? And you say, well, the only person I talked to is my good friend Jane. Well, they're going to call Jane to the witness stand, and Jane's going to have to raise her hand and say, I promise to tell the whole truth, nothing but the truth. And when Jane gets on the witness stand, she's going to have trouble remembering what happened 2 years ago. And she may not be aware of what she should and shouldn't say, and it can be a big, huge problem. So I can't stress that enough. Please know that any notes, calendars that you've kept, any conversations, are all what we call discoverable items. Because an attorney's going to be looking for the discovery. Anything they can find. If you're a legal nurse consultant and you're hired by an attorney to look at records, you don't ever want to give your reports to the plaintiff's side. They only go to whoever hired you to look at those records, because that becomes discoverable. A notice of intent is sent out 30 days saying that we're going to subpoena you, like a hospital or a clinic or whatever, for your records. As a 30-day notice to be sort of getting all those things together. We're giving you a warning. And that's the notice of intent. And then after 30 days, the actual subpoena goes out. And it says any and all records, and that means everything. And there's been many times when I've known that I did not get all of the records. And the reason I knew I didn't get all of them is because I didn't have a copy of the driver's license or the insurance card. So that told me they didn't copy everything that was in the chart. So any and all is important. It doesn't look like you're trying to hide something. But once you've done all of that and the patient's stabilized, and the fear of a lawsuit can creep into your mind if you think something's going to happen, the best way is to carry out 2 common sense steps. And the first one is to notify your manager and request the appropriate incident report form so that you can document it, and it looks like you're not trying to hide it. There's some last words by Earl Schoaf. That's, don't wish it were easier, wish you were better. Don't wish for fewer problems, wish for more skills. And don't wish for less challenges, wish for more wisdom. And Leo Buscaglia says, too often we underestimate the power of a touch, a smile, a kind word, a listening ear, and honest accomplishment are the smallest act of caring, and all of which have the potential to turn a life around. And they can also turn a lawsuit around. I think often, and I try to tell my students all the time, that the art of nursing is just as important, if not more, than the science of nursing. And that's because I think about my father who had a collapsed lung, and we were at the hospital in Montgomery, and they didn't have any rooms, and we went down to what I call the dungeon. It was like a basement area. It was like a holding area, and he was in a comfortable bed resting with care, and I had been up and was so worn out. And it was that nurse who brought me that blanket in that freezing cold room and that cup of coffee that was my angel. And when you do kind things for people and you implement that art, the chances of a lawsuit are much lighter or less because people feel cared about. They realize you didn't have an intent to harm them. And this is the last slide. It's a reference slide. And I hope that you've gotten something out of this presentation, and I do thank you for logging on to listen to this today, and I hope it has been beneficial in some way. Thank you so much.